Today in this class, we will be discussing Article 33, Article 34 and Article 35. So Article 33. So in this fundamental rights, continuing with our fundamental rights, what is Article 33? These Article 33 is applicable to certain section of the people. That is, Article 33 gives power to the Parliament to curtail or to limit certain fundamental rights to certain sections of the people. Here when we say certain section of the people, they are not a normal citizen. They are personnel who is involved in armed forces. Sayuda Dalalu. So these people work in armed forces. Armed forces also includes army, military, that is army. They also includes paramilitary forces, police personnel and other personnel who is working in intelligence, like we know Intelligence Bureau, we know RAW, Research and Analysis Wing. So all those personnel who are engaged in protecting law and order, in protecting lives of the people, in protecting and ensuring that the security of the state is protected. So armed forces here are basically Indian Army, Indian Navy, Indian Air Force, and we know paramilitary forces. Even paramilitary forces are also included in armed forces. Just to have a brief idea, armed forces under Article 33, it empowers the Parliament to limit or to place restrictions on the fundamental rights for the persons involved in armed forces. ఎవరైతే ఆర్మ్డ్ ఫోర్సెస్లో ఉంటారో సాయుధ దళాలు, వాళ్ళకి ఒక పార్లమెంట్ ఒక పవర్ తీసుకుంటుంది. ఆ పవర్ ద్వారా వీళ్ళని ఫండమెంటల్ రైట్స్, ప్రాథమిక హక్కులపైన కొద్ది నియంత్రణ పెట్టడానికి ఈ ఆర్టికల్ పార్లమెంట్కి ఎంపవర్ చేస్తుంది. At the same way, we know martial law. This is under Article 34. Martial law, సైనిక చట్టం. This law is different from ordinary law. We have many ordinary law. We have many laws which are passed by Parliament, implemented by executive agencies. But this is different. Martial law is a special law where the administration, that is the civil administration, is completely taken over by military. That is, there is a military law, or we can say military rule. This word martial law we have taken from England, that is English. What happens when martial law is imposed? The general administration, that is the civil administration, does not function as per the ordinary law. So here military rule will prevail. So under military rule, everything will be changed. Ordinary laws are temporarily suspended. This is what we discuss in Article 34. That is, Article 34 empowers military to govern the place where that martial law is implemented. And what is Article 35? Affecting certain fundamental rights. Chattabadhata Sikshana. We just have a revision that we also said fundamental rights are of two types. One, some are self-executory. Some fundamental rights are self-executory. That is, they get to be implemented on its own. And some fundamental rights should have a law, a prescribed law to get implementation. So that is the Parliament. Parliament is the sovereign authority to pass certain law to implement certain fundamental rights. So not all fundamental rights are implemented on their own. Some are self-executory and some have to be implemented by certain laws. And it is the Parliament which executes or which formulates these law and bring a rule or bring a law on which certain fundamental rights are being implemented. And we also have certain fundamental rights where the court has to punish, or there is a detailed explanation that if any fundamental law or fundamental right is violated, then there have to be some punishment. For example, we know that if there is an untouchability under Article 17, we have prohibition of untouchability. If any person involves in the process of untouchability, then he will be penalized or he will be punished. For example, we have child labor. If anyone admits a child and makes him to work against their interest, then he is penalized, he is punished. So all those laws which penalizes a person are under this act. So Act 35, that is, according to this article, it will empower the parliament to bring certain law and also to determine what kind of punishment is given if anyone violates such law. So basically we have these three types. Here Article 33 empowers the parliament to restrict certain fundamental rights on these armed forces. And martial law, again, it is the right, it is the power of the parliament to impose martial law when there is a threat to law and order of the society, or if there is a threat to the security of the state, or there is a threat to the integrity of the state. So martial law is imposed when ordinary law is break down, when there is a need to restore the law and order and peace. And Article 35 empowers Parliament to bring certain laws and also decide the nature of the punishment if any fundamental right has been breached. So briefly, we have to know this Article 33, 34 and 35. Getting into the details. So Article 33, as we said, it empowers the Parliament to restrict or obligate or curtail certain fundamental rights to these sections of the people. Obviously, armed forces are not ordinary personnel. They are the forces involved in protection of people, protection and safeguarding our boundaries whenever there is a war or external aggression. So armed forces people means we have three kinds of armed forces: in general, that is army, we have navy, and we have air force. So armed forces generally they are army, navy and air force. So they are involved in protection of the nation, protection of our boundaries from external aggression or war. They have their own rules, they have their own laws, or they are different from what a common man, a common citizen is. So obviously they do not enjoy all those fundamental rights which in general are enjoyed by ordinary people. We also say paramilitary forces. They are also armed forces, but their duty is to protect the lives and property of the people. So paramilitary forces are of various types generally. We know CISF, Central Industrial Security Force, CRPF, Central Reserve Force, we have Indo-Tibetan Border Post, we have BSF, Border Security Force, Shasastra Seema Bal, SSB, Assam Rifles. So we have different kinds of paramilitary forces which are engaged in protection of life, safety and property of the citizen of India. They are also supplementary in protecting the national boundaries. And we have police forces. Generally we see, we have police is under state list. State law and order is controlled by the state administration. So police, in police also we have law and order, we have intelligence, we have crime bureau, we have special police, we have reserve police. So many kinds of police forces working for the safety and security of the people, working for the protection of law and order. So all these forces can not enjoy the same fundamental rights as common people does. So fundamental rights are not equally applicable to all these personals. When we say intelligence agencies, even these are also come under armed forces or police forces, because they also involve in security of the state, for protection of the security of the state. So in intelligence, we have intelligence bureau, we have research and analysis wing, and many other agencies. So Article 33 empowers Parliament to contain or to put restrictions on these forces or these personnel in the enjoyment of fundamental rights. So they cannot demand for the fundamental rights. So if there is any fundamental right which has been abridged or which has been taken away, the armed forces cannot move the court saying that our fundamental rights has been abridged. So to limit, to contain their fundamental rights, Parliament has the sovereign power, and we can say that Parliament has an exclusive power in containing or putting restriction on fundamental rights for these personnel. Why it is only Parliament? Why it is not state assemblies? Because defense is a subject which comes under central list, that is union list, and as defense is a subject under union list, only Parliament has the authority to create such laws, and which is applicable throughout the territory of India. So for the application of uniformity under this law, only Parliament has the power to impose restrictions on these agencies. సో ఆర్మ్డ్ ఫోర్సెస్ కానివ్వండి, పారామిలిటరీ ఫోర్స్, పోలీస్ ఫోర్స్, ఇంటెలిజెన్స్ ఏజెన్సీస్, వీటిలో పనిచేస్తున్న సాయుధ దళాల యొక్క ప్రాథమిక హక్కులపైన నియంత్రించే పవర్ ఓన్లీ పార్లమెంట్కి మాత్రమే ఉంది. ఎందుకంటే పార్లమెంట్ ఈజ్ ద సుప్రీం అథారిటీ విచ్ ఈజ్ ద హైయెస్ట్ అథారిటీ టు పాస్ అ లెజిస్లేషన్ విచ్ ఈజ్ అప్లికబుల్ త్రూ అవుట్ ద టెరిటరీ ఆఫ్ ఇండియా. సో ఆర్టికల్ 33 అనేది స్పెషల్ ఫోర్సెస్, ఈ ఆర్మ్డ్ ఫోర్సెస్, పోలీస్ కానివ్వండి, పారామిలిటరీ ఫోర్స్ కానివ్వండి, వాళ్ళ యొక్క ప్రాథమిక హక్కులను నియంత్రించే అంశము. విల్ మూవ్ ఆన్. సో వై వీ నీడ్ టు రిస్ట్రిక్ట్ దీస్ ఫండమెంటల్ రైట్స్? ద మెయిన్ రీజన్ టు కంటైన్ ఆర్ టు రిస్ట్రిక్ట్ దిస్ ఫండమెంటల్ రైట్స్ for all these sections of the people is that to ensure their proper discharge of duties. Here, when we say to ensure the proper discharge of the duties, if just assume if those personnel having all the fundamental rights, what generally their nature of job is to work for many hours in a day, to work in harsh conditions, some of the time they won't be getting leave, so they cannot move court for implementation of fundamental rights, because it is the nature of the duty that demands something extraordinary from those people. So these people or the personnel who is working under armed forces will obviously do not have such freedom as common people enjoy. For example, we say a common people, a common citizen under Article 19 Clause 1, he has all the freedom to speak, to express, to form assembly, to form union, to move anywhere throughout the India. So all these things a police personnel or armed force personnel cannot enjoy. A military officer cannot have a press meet voluntarily. He cannot speak whatever he wants to speak. They cannot form unions. They cannot participate in political rallies. They cannot participate in demonstrations. So generally thinking, armed forces, be it paramilitary force, police force, intelligence, all these personnel do have their certain limitations. Once they entered into the job, they have to follow certain rules which are obviously very strict rules. So common ga ఈ ఆర్మ్డ్ ఫోర్సెస్ అంతా మనము సాయుధ దళాలు, పోలీస్ కానివ్వండి, పారామిలిటరీ కానివ్వండి, ఇంటెలిజెన్స్ కానివ్వండి, వారు ఒక అగ్రిమెంట్ ఉంటుంది వాళ్ళకి, ఆ జాబ్లో ఎంటర్ అయిన తర్వాత వాళ్ళు ఈ ప్రాథమిక హక్కులు అనేది పూర్తి స్థాయిలో ఒక కామన్ సిటిజన్ ఎంజాయ్ చేసినట్టు ఎంజాయ్ చేయలేరు. బికాస్ వాళ్ళు చేసే వృత్తి అలాంటిది. ద నేచర్ ఆఫ్ జాబ్ డిమాండ్స్ దెమ్ టు హ్యావ్ రిస్ట్రిక్షన్స్ ఆన్ ఫండమెంటల్ రైట్స్. That is the reason why Parliament is empowered to put restrictions on personnel of armed forces. That is one thing, because to discharge their duties properly and to have discipline among themselves. When we say generally a fundamental right is a person should not work, like they have to provide a decent livelihood, that is not to work beyond 8 hours or 12 hours. The same thing we cannot apply for armed forces. So to bring or to instill discipline among them, Parliament could curtail or could restrict certain fundamental rights. And this power, that is under Article 33, power to restrict fundamental rights and its applicability is given to only Parliament and not state legislature. Only Parliament has the power to put restrictions on fundamental rights of armed forces. So states cannot pass any law regarding fundamental rights, and Parliament has passed many legislations, or it has brought many laws which restrict fundamental rights of armed forces. We have Army Act 1950, Navy Act 1950, Air Force Act 1950, and we have many acts regarding police forces, restriction of rights, that is a policeman cannot participate in political rallies, cannot make himself involved with any political party. They do not have unions, they cannot go on strike, they cannot demand for a leave, because that is the nature of their job. When everyone enjoys the fundamental rights, armed personnel or police personnel will work without questioning on their fundamental rights. They can't even move Supreme Court regarding exception of certain fundamental rights. So these officers do not enjoy all fundamental rights what a common citizen will enjoy. So many acts brought by the Parliament, border security force, we have military law. So these are the laws which have brought by Parliament. So that is Article 33. And one thing we need to know, that Article 33 is restricting fundamental rights of armed forces. They are talking about personnel. So Article 34 talks about fundamental rights and restrictions within a area, within a place. So here area means martial law is imposed in certain place where there is a breakdown of law and order. Whenever there is a breakdown of law and order, or there is a disturbance in kind of violence, in kind of riot or anything, in that situation, if the problem or the violence is not in control by police administration, that is local police, then the Parliament has the power to impose martial law in such places. So martial law is imposing a military rule. We know what military rule is. In military rule, the civil administration is completely taken by military authorities. So for a temporary period, the civil administration comes in the control of military authorities or military. So we cannot expect a common or a civil administration to work, because to restore the peace or to restore the law and order, there have to have some kind of force to stop the force which has created the violence. So to repel that violence, we need to have a same kind of force to restore and to maintain the peace and stability, the tranquility and harmony of that particular place. So that is the need of martial law. Again, to not confuse the martial law with national emergency. National emergency is of different kind. Martial law is generally imposed in certain parts of the area, or we can say in certain part or a district of the state, which is disturbed by certain miscriminants or a social evil factors. So there may be a violence regarding communal things, there may be a mob violence, there may be a small disturbance where there is a threat to law and order or life and property of the common people. So to contain these activities, these violent activities, immediately there is a need to impose martial law to restore the law and order. Generally, we seen this in areas of sensitive disturbances. For example, in northeastern states, in states like Jammu Kashmir, in places which are bordering to our neighboring countries like China, Pakistan, Bangladesh, etc. So martial law is generally imposed to restore peace and stability. మార్షల్ అనేది ఒక సైనిక చట్టం. ఒక కామన్ అడ్మినిస్ట్రేషన్ ఫెయిల్ అయితే, వాళ్ళ అడ్మినిస్ట్రేషన్లో ఫెయిల్ అయితే మార్షల్ లా ఇంపోజ్ చేయడం జరుగుతుంది. మార్షల్ లా పెట్టిన తర్వాత, సైనిక చట్టం అక్కడ అమలు చేసిన తర్వాత సివిల్ అడ్మినిస్ట్రేషన్, మామూలుగా ఒక సివిల్ అడ్మినిస్ట్రేషన్ అనేది కంప్లీట్లీ మిలిటరీ చేతిలో వెళ్ళిపోతుంది. సో దిస్ ఈజ్ వేర్ దేర్ ఈజ్ అ టెంపరరీ సస్పెన్షన్ ఆఫ్ సివిల్ అడ్మినిస్ట్రేషన్. So Article 34 empowers the Parliament to restrict fundamental rights. Here Parliament has all the power to restrict fundamental rights of people, of general people who are living in the area where there is martial law. We can say that in any district, if martial law is imposed, the people living there cannot go to the court, cannot approach the court saying that our fundamental right to move freely has been taken away. Because in extraordinary conditions, such steps has to be taken by the central government to restore the peace or to stop the violence and to protect the property and lives of the common people. So under military law, fundamental rights are restricted for the common people, of their people. So this also empowers the Parliament to protect the officers who are involved in martial law. They are government officers, be it military officers or any such officer. The government will protect their actions so that they could work independently, they could work with some confidence. That is what we call indemnify. The government will indemnify those officers or those people involved in protection of law and order or who are part of armed forces or military. So it empowers the Parliament to indemnify any government servant for any act where it is needed to maintain the law and order. For example, in certain conditions, in martial law is prevailing there, if martial law is imposed on certain part of the country, so the common man there cannot move freely. What if a common man or a person comes out and shouts slogans against the country? Then definitely there will be some force done by officers, and that person who has been injured or who has been died, he or anyone behalf of him cannot move Supreme Court, because under martial law those civil administration is temporarily suspended. So government, that is the central government, that is the Parliament, has the power to impose restrictions on fundamental rights of people too. So when we say Article 33, it empowers Parliament to impose fundamental rights and restrictions on fundamental rights on certain sections of the people, that is armed forces, paramilitary forces, police forces, intelligence agencies. Here it is talking about personnel, that is person. In Article 34, the restriction is imposed on a place. So that particular place is under martial law. So any actions occurring on that place and where fundamental rights has been abridged, government is not providing any guarantee for the fundamental rights or abridge of the fundamental rights, that common man cannot move Supreme Court or High Court either. So that is what we call martial law, Sainika Chattam. Martial law is also called military rule. It is a military rule. We have brought this from English. So just not imposing restriction on fundamental rights. Parliament has the power to make sure that whatever the action is done by that personnel or by the armed forces is validated. Parliament says that all actions, whatever actions the officers have taken, like punishing someone or making someone forfeiting their property, taking away their rights, all these actions is validated. So whenever there is a martial law in certain part of the country, there the government validates the actions of the police personnel or military personnel. All these actions cannot be challenged in the court. So when martial law is imposed on certain section or certain part of the country, whatever happens there may be many things, fundamental rights may be breached, certain sections of the people may go to court, thinking to go to court for the breach of their fundamental rights, but such cases are not entertained by the court under martial law when the martial law is imposed there. Otherwise, under general conditions, under ordinary conditions, any person who has got breached their fundamental rights or their fundamental rights is violated, then such person can move Supreme Court under Article 32 and can move High Court under Article 226. That is under normal conditions, that is under ordinary conditions. But when in emergency conditions, when there is martial law applicable there, no person could move court saying that my fundamental rights has been breached. This harsh step by central government is to restore as soon as possible, as early as possible, to bring normalcy in that area. Otherwise, it may lead to further difficulties, or there may be a threat to life of the people, there may be a threat to property. So to restore normalcy, generally central government will resort to martial law, which is a necessary under circumstances. So this martial law is borrowed from English common law. No one can challenge that their fundamental rights are breached under martial law. So మార్షల్ లా అంటే మిలిటరీ లా. ఇలాంటి పరిస్థితిలో మార్షల్ లా ఎప్పుడైతే విధిస్తారో అప్పుడు పౌర పరిపాలన, దట్ ఈస్ సివిల్ అడ్మినిస్ట్రేషన్ ఈజ్ కంప్లీట్లీ టేకెన్ అవే బై మిలిటరీ. పౌర పరిపాలనను సైనిక అధికారులు నడుపుతున్నారు. అంటే ఎవ్రీథింగ్, ఆల్ ద సివిల్ అడ్మినిస్ట్రేషన్స్ హ్యాస్ బీన్ టేకెన్ ఓవర్ బై military people. So what military people generally do, they have their own rules, they have their own rule book, own style of working. So they generally follow their rules and regulations framed under their law. So when we generally impose martial law, as I said, martial law అనేది extraordinary circumstances మాత్రం లో వాడతారు. కామన్గా ఆర్డినరీ నార్మల్సీ ఉన్నప్పుడు, పబ్లిక్ పీస్ కరెక్ట్గా ఉన్నప్పుడు మార్షల్ లా అనేది యూజ్ చేయము. బట్ ఎక్కడైతే నేషనల్ సెక్యూరిటీకి థ్రెట్ ఉందో, కామన్ సిటిజన్ వాళ్ళ లైఫ్ ప్రాపర్టీకి థ్రెట్ ఉందో, అలాంటప్పుడే మార్షల్ లా మనం విధించవచ్చు. సో మార్షల్ లా ఈజ్ ఎక్స్పోజ్డ్ ఆర్ ఇట్ హ్యాస్ బీన్ applicable in certain circumstances. That is when we have war, when there is a threat of invasion. When there is a threat of invasion, that is when the neighboring countries has invading our country or few parts of the boundaries. when there is a rebellion within the country. So in these circumstances, when we say riot, it's a kind of violence, be it communal violence, be it mob violence. So under these circumstances, when normal law and order managed by the police, state police, is failed, so there is a situation which had gone beyond the state police authority or control, then martial law is imposed. So when state police says that this situation is not under our control, the battalion will come, the military people will come and take over the charges of that area. So entire civil administration is taken over by military authorities, and when that administration is under military, their military rule will apply, and military rule is not similar to ordinary rules. They have some extraordinary power. They could use some harsh methods to bring the normalcy in certain areas. So these people have given special powers. For example, we have Armed Forces Protection Act. So Armed Forces Special Protection Act is an act where these armed forces is being protected by the government. Their action cannot be questioned in the court. So they generally given more powers, that is extra powers, to limit the situations or to contain the situations which could at sometimes go beyond the control. It could lead to further damage for the security of the state. So Parliament is empowered to bring certain laws and empower personnel to act without any fear. So why martial law? As we said, martial law is imposed to restore the normalcy. That is, once there is a breakdown of law and order, with the same force, martial law would bring normalcy. That is, they repel by force to stop violence, to stop mob. The same kind of force should be used. It could be harsh, it could take away fundamental rights of many such people. Many people or citizen of that place could be arrested and detained. Many people could face lathi charge or similar things. They cannot go to court saying that our fundamental rights has been breached, because here there is a martial law. We do not have an ordinary law, and ordinary legislations cannot work when there is imposition of martial law. So the Supreme Court held, sometimes the Supreme Court also says that mere applicable of martial law cannot take away the fundamental right of issuing habeas corpus. Habeas corpus is a type of writ. Habeas corpus is where a Supreme Court or High Court empowered to issue writ to bring the body. That is, when there is an illegal detention, the court could issue writ. So just application of martial law doesn't take away the power of issuing writ. Declaration of martial law under this article, which is different. See, martial law, as I said, application of martial law is different from national emergency. National emergency, which is imposed under Article 352, is quite different. National emergency could be imposed on entire country or some parts of the country, but martial law is imposed for a specific reason. It is more applied in a small geographical entity or a small area where there is a breakdown of local law and order. So we have a difference in Article 34, that is martial law, and Article 352, that is national emergency. National emergency is imposed where we have a threat to security of our state at large, where there is a war, external aggression. So declaration of martial law, where we have to know the difference between martial law and national emergency. The difference is, in martial law, only fundamental rights has been taken away, or this affects only fundamental rights. సైనిక చట్టము విధించినప్పుడు మన ప్రాథమిక హక్కులను మాత్రమే ఎఫెక్ట్ చేస్తుంది. అదే నేషనల్ ఎమర్జెన్సీలో, దట్ ఈస్ అండర్ ఆర్టికల్ 352, మెనీ థింగ్స్ ఇంక్లూడింగ్ ఫండమెంటల్ రైట్స్, సెంటర్ స్టేట్ రిలేషన్ ఈజ్ ఎఫెక్టెడ్. ద financial relation between center and state, be it revenue sharing, grant in aid, all these things are restricted when we apply national emergency under article 352. It's not only fundamental rights but center state relations, legislative powers between center and state, and also there can be extension of tenure of the parliament when national emergency is imposed. That is not happening in martial law. Martial law only affects fundamental rights. So in martial law, the difference is this suspends the government and ordinary law courts. Ordinary law courts are also suspended because we have a need to restore the normalcy or bring the public order and peace and harmony back. Here in national emergency, ordinary courts are functioning. There is nothing to do with ordinary courts. Ordinary courts will generally function. And martial law is imposed when there is a breakdown of law and order to restore the normalcy. The damage has already done. To restore law and order, to prevail harmony, martial law is imposed. It can be imposed on 3 grounds. When I talk about national emergency, generally this is imposed on 3 grounds: war, external aggression and armed rebellion. On 3 grounds under article 352, national emergency could be imposed. So national emergency can be imposed on whole part of the country, that is on entire country, or on certain part or any part of it. So it is not that national emergency means it is imposed on entire country. Where we have a threat, certain places, on such places only national emergency could be imposed. And here it is imposed on specific area of the country. It is only imposed on the specific areas of the country. Martial law as national emergency cannot be imposed on entire country. So సైనిక చట్టం అనేది కొన్ని ప్రాంతాలు మాత్రమే పరిమితం అవుతుంది. ఎక్కడైతే నార్మల్సీ ఉండదో, పబ్లిక్ ఆర్డర్ ఫెయిల్ అవుతుందో అక్కడ మాత్రం మనము మార్షల్ లా విధించవచ్చు. అదే నేషనల్ ఎమర్జెన్సీ అనుకోండి, అది మొత్తం కంట్రీకి కానీ కొన్ని ప్రాంతాలకి మాత్రం విధించవచ్చు. సో as we have seen, martial law is nowhere explained in our constitution. It has not been defined anywhere in our constitution. It is implicit in article 34. 34 మాత్రమే చెప్తుంది మనకి మార్షల్ లా గురించి. We have no specific provisions regarding martial law, but it is clearly mentioned in article 352 about national emergency. We have a detailed explanations. We have a provisions regarding article 352. So this is the difference between martial law and national emergency. Again, I need to reiterate that martial law is imposed to restore normalcy as soon as possible and to minimize the damages caused for both life and property of common people. Okay, the main difference between article 33 and 34. So when we say article 33 is to restrict fundamental rights and its applicability on certain section of the people, article 33 empowers the parliament to impose restrictions to curtail fundamental rights on certain sections of the people, that is armed forces, paramilitary forces, police personnel, intelligence agencies, etc. So this is basically on certain section. ఆర్టికల్ 33 కొన్ని వర్గాల ఉద్యోగులకు మాత్రమే వాటి హక్కులను నియంత్రిస్తుంది. సో వాళ్ళ మెయిన్ ఫండమెంటల్ రైట్స్ని కంటైన్ చేస్తుంది. సో హియర్ సెక్షన్ ఆఫ్ ద పీపుల్, కొంతమంది వర్గాలకు మాత్రమే. 34 అనేది ప్రాంతాలకు సంబంధించింది. మనం ఎక్కడైతే సైనిక చట్టం అమలు చేస్తామో ఆ ప్రాంతానికి మాత్రం అక్కడ నివసిస్తున్న ప్రజల యొక్క హక్కులని నియంత్రించడానికి. సో ఆర్టికల్ 33 is about section of the people, వర్గాలు. ఆర్టికల్ 34 is about the geographical entity or the place where that martial law has been imposed, that is prantalu. So that is the main difference between Article 33 and 34. 33 talks about certain section of the people, and 34 talks about that particular place where martial law has been imposed. And important again, Article 35, which is the last right under fundamental rights under part 3. So this right, that is Article 35, empowers the parliament to bring certain laws or to frame certain laws to implement these fundamental rights. Fundamental rights ni, ప్రాథమిక హక్కుల్ని ఇంప్లిమెంట్ చేయడానికి కొన్ని చట్టాలు అవసరము. సో పార్లమెంట్ అలాంటి చట్టాలని తీసుకోవడానికి ఆర్టికల్ 35 ఎంపవర్ చేస్తుంది. సో ఆర్టికల్ 35 empowers the parliament to bring certain laws for implementation of the fundamental rights. As I said, all fundamental rights are not self-executory. For few fundamental rights, there has to be a backup of legislation. So that is one thing where Article 35 empowers the parliament to bring certain laws for the applicability or implementation of fundamental rights. And it also empowers the parliament to decide on the nature of the punishment given when someone is indulged in violation of fundamental rights. So శిక్ష ఎంత పడాలి ఒకవేళ ఒక పౌరుడు ఫండమెంటల్ రైట్స్ని అధిగమించడం జరిగితే, ఇఫ్ సమ్వన్ వైలేట్స్ fundamental rights or some state or some agency violates fundamental rights, then what kind of punishment is imposed? That is also decided by the parliament. Parliament will bring such laws where what kind of punishment is to be given for that particular agency, be it a person, state or any corporation which is involved in abrogation of the fundamental rights. So Article 35 ensures that the fundamental rights are implemented, or its nature, its scope is uniform throughout the nation. So to bring that uniformity, it is only parliament, that is parliament is the sovereign authority in our country, which has the ultimate power to decide or to make law which is applicable in entire territory of India. So only parliament could decide on such laws, and it also prescribe certain punishments. So to ensure that there is a uniformity throughout the India with regard to the nature and the punishment, this is also given by Article 35. Article 35 decides that how much punishment should be given, what kind of punishment should be given. For example, in case of child labor, if a person employs a child below 14 years of age, then he will be punished with a fine of from 20,000 to 50,000, and he will be sent to prison for 2 to 3 years of term. So this is decided by the legislature. When the legislation is made, when the policy is formulated, every simple details will be there in that legislation. So Parliament will also bring laws and also prescribe punishment for the violation of such law. So we have certain things. Article 16 says there should be a equal opportunity in public employment. So in certain things, Parliament will bring certain laws. So even writs, we have 5 kinds of writs. We have writs of habeas corpus, mandamus, prohibition, certiorari, quo warranto, ఇలాంటి చాలా రిట్స్ ఉన్నాయి. ఆ రిట్స్ జారీ చేసే హక్కు ప్రస్తుతానికి సుప్రీంకోర్టు ఆర్టికల్ 32 ప్రకారం సుప్రీంకోర్టుకి, ఆర్టికల్ 226 ప్రకారం హైకోర్టుకి ఈ రిట్స్ జారీ చేసే హక్కు ఉంది. ఆ 2 కోర్ట్స్ తప్ప వేరే కోర్ట్ రిట్స్ జారీ చేయకూడదు. కానీ అలాంటి కోర్ట్స్ కూడా అదర్ దెన్ హైకోర్ట్ అండ్ సుప్రీం కోర్ట్ ఈ రిట్స్ జారీ చేసే అధికారాన్ని వేరే కోర్టుకి కూడా ఇవ్వబడుతుంది. అది పార్లమెంట్ ఆ చట్టం తీసుకొస్తే. సో పార్లమెంట్ హ్యాస్ ద పవర్ టు ఇష్యూ రిట్స్, టు empower other court to issue writs అదర్ దాన్ హైకోర్ట్ అండ్ సుప్రీం కోర్ట్. సో అలాంటిది కూడా ఆర్టికల్ 35 చెప్తుంది. ఆర్టికల్ 35 empowers the parliament to give power to issue writs for other courts also. సో మెనీ థింగ్స్, ఫర్ ఎగ్జాంపుల్ ఆర్టికల్ 33 ఏం చెప్తుంది, ప్రాథమిక హక్కులు అనేది ఆర్మ్డ్ ఫోర్సెస్కి అందరిలాగా వర్తించదు. కొన్ని నియంత్రణ తీసుకురావచ్చు పార్లమెంట్ ఆర్మ్డ్ ఫోర్సెస్ యొక్క ప్రాథమిక హక్కుల పైన. అలానే ఆర్టికల్ 34 ఎక్కడైతే సైనిక చట్టం అమల్లో ఉందో అక్కడ ఆ ప్రాంతంలో నివసించే వారికి కానీ అక్కడ ఉన్న ఆర్మ్ ఫోర్సెస్ వారికి కానీ ఆ ప్రాథమిక హక్కులు అనేది అప్లికబుల్ అవ్వదు. సో అలాంటి కొన్ని చట్టాలు తీసుకొచ్చే హక్కు పూర్తిగా పార్లమెంట్ దగ్గర ఉంది. అదే ఆర్టికల్ 35. We have said that Article 35 gives the Parliament a power to bring certain law and also bring the nature or the type of punishment. So this is Article 35. So we have many forces, things like this, where Parliament will decide on what kind of punishment to be made for breaching certain fundamental rights. When we say Article 17, it talks about untouchability. If anyone practices untouchability, Parliament would obviously come with a very stringent law and also punishment so that the fundamental right is been restored or the social evil like untouchability is not practiced. We also have a traffic in human beings. This we have discussed in Article 23. Here human beings involves men, women and also children. So if there is any action which is against the human rights or natural justice, then such actions will be prosecuted or such persons will be punished with stringent laws. సో ట్రాఫిక్లో, హ్యూమన్ ట్రాఫిక్స్లో మనం చాలా చూసాము. ఇది రైట్ అగెయిన్స్ట్ ఎక్స్ప్లాయిటేషన్లో చదువుతాం మనము. సో ట్రాఫికింగ్లో ఏమైనా ఉండొచ్చు, ప్రాస్టిట్యూషన్ కానీ, బేగర్ సిస్టమ్, జోగిని సిస్టమ్, దేవదాసి సిస్టమ్, ఇలాంటివి చాలా మనం చూస్తాము. సో అలాంటి దానికి చాలా స్ట్రింజెంట్ పనిష్మెంట్స్ ఉంటాయి. పార్లమెంట్ దాన్ని ఆ చట్టాలని తీసుకొస్తుంది. సో ఫోర్స్ లేబర్ ఆర్ బాండెడ్ లేబర్, ఆల్ దిస్ ఆర్ ద థింగ్స్ where the parliament has the power to bring law and also give the nature of the punishment, to decide on the nature of the punishment. One thing we have regarding Article 35A, when we say Article 35, it has given some special provisions. Article 370 gives certain special provisions for certain section of the people. For example, in Telangana we have Article 370D, where the parliament has given special provisions for the in case of employment. The same way in Jammu Kashmir we had this. So special powers vested in president regarding Article 370. So what is Article 368 again? Article 368 is where the president has the power, or the constitution, the parliament has the power to amend certain provisions of the constitution.